The beneficiary, yes.
Do you? Who the person I'm talking to, is that the person who is in this property at 2170 East Jefferson? You're not answering my question.
He failed to appear, so I'd like the case to be dismissed.
There's a fine here of $500, and your license to carry concealed is being suspended for 6 months.
All right.
Sir, I'm not entertaining those questions.
Yes.
Those are sovereign citizens' questions, and I'm not answering those questions. So I'm going to mute you for right now. I have jurisdiction over you.
I objected. No, listen, let me talk. I objected to the non-judicious before, I objected to him now.
Listen, your objection is duly noted. You have.
Mr. Simmons, if you are recording this proceeding, I am going to hold you in contempt, and I can issue another warrant for your arrest. You are not to record this proceeding.
I'm not actually recording.
Stop interrupting me, sir. I'll just hold you in contempt of court for 90 days, and then you can just sit there anyway for it.
Are you recording this proceeding, Mr. Simmons?
No, I'm not recording this proceeding at all.
Calling case number, thank you. Calling case number 22393437. This is Pasadena Investments LLC versus Dwayne Davis Jr. and all occupants at 2170 East Jefferson, Unit 1007.
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548 on behalf of the plaintiff. Your Honor, Mr. Davis at this time owes $6,706, court cost of $157. This is a subsequent hearing.
All right, Mr. Davis or Ms. Davis? Okay,
Yeah,
I'm the
beneficiary of Dwayne Davis right here. The beneficiary.
What is it?
Are you Dwayne? Are you Dwayne? Excuse me. Are you Dwayne Davis Jr.?
I'm the beneficiary owner right here.
Do you reside at 2170 East Jefferson, Unit 1007?
Yes, the estate does assign there.
Do you reside in that property?
The beneficiary, yes.
Do you? Who the person I'm talking to, is that the person who is in this property at 2170 East Jefferson? You're not answering my question.
I don't fully understand it. Say it again.
All right, okay. At this point, I don't see anyone who resides at 2170 East Jefferson, Unit 1007. If you do reside there, please make the court aware of it.
Okay.
Your Honor, since the defendant has not identified himself as the defendant in this particular case.
I just did. I just told you I'm the beneficiary.
Your Honor,
Of the name.
Your Honor, since the defendant has not identified himself as a person in this property, he's attempting to try to act like he's a sovereign. This property is owned and is an apartment building. We're asking for a default judgment at this time. If he decides to pay it, that's great. If not, we'll be moving forward after time expires.
Before we proceed with this matter, can I ask the director of the beneficiary? I'm talking to the plaintiff, sir. My legal person, I'm showing you right here, a corporation. Can you write me in 21 days and provide me evidence that you have legal?
Your Honor, none of that
I just want to know.
required by law in this court. I'm asking for a default judgment this time. Quit wasting the court's time. If he wants to file the appropriate court paper or identify himself to the court as you've requested on numerous occasions, then we can proceed forward. At this time, playing these legal games is against. I
have a birth certificate right here.
Against the law. Two, we provide the court with a lease agreement. We provide the court with the ledger. We're asking for a default judgment.
The court is in receipt of a summons, a complaint, a demand for non-payment of rent, as well as a lease agreement.
The summons was never notarized.
Signed with Dwayne Davis Jr., as well as the proof of service. Mr. Davis, Dwayne Davis Jr., how much is your monthly rent?
I want to say 900.
When's the last time you paid rent?
Long time. Siri paid my back balance, but Pasadena never put it to my account. So I consider Pasadena either took the money or what. I don't know what they did with it, but Siri definitely paid it. It's on the record. It's on my the record with the Siri. You can find it in their profile. But they're supposed to pay my back balance.
I can't find it in my profile. So you qualify. Sarah paid. How much did Sarah pay?
They paid up to like September, but they didn't pay they're supposed to pay July, August, September, but Pasadena never put that to my account.
Your Honor, if it wasn't applied, my client didn't receive it. That is not our burden. It's his burden.
But that's in documents though that they were supposed to pay. I have it in documents.
Your Honor, I'm not going to sit and argue all day, Your Honor. Bottom line is, the money is for his benefit. It is not for my client's benefit. Just like paying a mortgage payment. If I send a mortgage payment in, if it's not received, it's still on me. If you send a mortgage payment on my behalf and it's not received, it's still on the person who has the mortgage. He's the renter. It is his responsibility to have the money paid, or to whoever's paying on his behalf, that we receive it. We have done everything we're supposed to do. The documentation speaks for itself. At this time, again, I'm requesting for either default judgment or judgment by hearing.
And then I'm talking to the plaintiff. Can you just write me and saying that you have authority as a public servant to me?
Your Honor, I am not writing.
I'm not Mr. Davis. This is a landlord-tenant court. This is summary proceedings. This is the second hearing, and you're afforded legal counsel. Legal counsel was available. They said that they could not assist you at this matter. Are you even identifying yourself as Dwayne Davis Jr.?
No, I'm the beneficiary of that name.
So are you not Dwayne Davis Jr.?
No, I am not. I am not.
Okay. We are entering, the court has not received the call or answer from Dwayne Davis Jr. Does anyone on this Zoom reside at 2170 East Jefferson, number 1007? Is anyone present who lives in that property on this Zoom?
Your Honor, again, no one's responded, asking for my default judgment. We can submit it to the court before the end of the day, along with a full ledger.
Default judgment granted.
Thank you, Judge.
Please submit the paperwork. Call it, you're free to leave. Well, nobody identified themselves, so calling the next case.
Calling yourself the beneficiary instead of the tenant may feel like taking control, but the court decides cases using legal responsibility, not personal labels. Once someone refuses to identify themselves in a proceeding that depends on legal identity, they risk losing the chance to argue the actual dispute. The focus shifts from the rent issue to whether they're willing to participate in the process at all.
We should be leaving tomorrow.
Who's in the hospital?
The victim and Martin.
Oh. All right, so People versus Martin.
Good afternoon, Your Honor. Don Schultz on behalf of the People, PA 7439.
Nicholas Darren on behalf of the defendant, Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could unmute yourself, state your name for the record.
Okay, I got it.
You got it.
All right, you hear me?
Yep.
All right.
So this is People versus Martin.
Yes, Your Honor. I have spoken with the complaining witness at the time. He would like to proceed with this case, and the people would ask to set it for a settlement conference before we go forward with trial to see if there's a resolution.
All right. And Mr. Darren?
I mean, Your Honor, I guess we're going to proceed that way. I was hoping, I'll renew my motion from the last time. Mr. Martin's been incarcerated, I think it's like 62, 63 days now. Court rule is pretty clear. If he's in over 28 days, he should be released on a personal bond. Mr. Martin's just been sitting in jail on this matter. I mean, I guess from practical, I would imagine the court's going to give him credit for time served, regardless of what the resolution is on this matter. Considering he's done over, at this point, he's done over 2/3 of what his original sentence would be. We're not going to accept an offer on this, and I guess we'll just set it for a settlement conference then, if that's what sister counsel wants.
And Your Honor, it's, I know this case has been going on for a while.
Personal bonds.
That's correct. The issue here is that him and the victim are brothers. They live at their family.
First, I want to deal with the whole bond thing. His bond is $2,500 personal.
So I think the issue with that is I was having a cover last week, but per the notes, if you recall, you ordered him not to return back to the property because there's a no contact order in place. 2 weeks ago, when Mr. Brother Counsel appeared for the first time on this case, I believe I agree, and that's when the bond was changed. But Mr. Martin, Judge Kirsten, yes.
So Your Honor, Judge Kirsten changed his bond, and then after some further statements were made, he changed his ruling to leave Mr. Martin in jail.
And that's because Mr. Martin made comments about returning back to the location, the home where the victim lives. And to my knowledge, per my conversation with Mr. Martin, the victim today, he indicated he'll be leaving the hospital, returning to that house tomorrow.
Right. All right. So I'm going to.
I mean, I have no objection.
Mr. Martin, now listen, you understand, I wasn't here, but Judge Kirsten, the original bond was $2,500 personal. Then he said it at $2,000 cash because of the alleged violation that says it says need to set a hearing on violation ASAP. I don't know if there was I don't see anything whether there's an alleged violation of the bond condition. Is that right?
Not an alleged violation. He made comments.
He made a comment about it.
That he'll return back to the house.
This is why something. All right. So you understand you can't go to that house while you're on that. That's one of the bonds in place. You understand that? Stay somewhere else. You understand that?
No, I do not understand it. I gotta stand up. First, I have nowhere else to go. Okay, so that's why I must return back there, and I objected. No, listen, let me talk. I objected to the bond conditions before, I'm objecting to them now.
Listen, your objection is duly noted. You have very, very highly competent counsel, so we'll just let your counsel speak on your behalf. And so he already did. He made a motion.
Well, I object to you speaking on behalf of that.
Stop interrupting me, sir. I'll just hold you in contempt of court for 90 days, and then you can just sit there anyway for it. Stop interrupting. Your Mr. Madera made a motion to set this for a personal bond. I'm going to set your bond at $2,500 personal. No contact with the victim or the victim's home location. If you show up at that location and violate my bond, you can be held in contempt of court. Just want to make sure you understand that. I'm just telling you that right now. So I'm setting your bond at $2,500. I'm granting the defendant attorney's motion. And the bond's $2,500 personal. No contact with the victim. And no live in the state of Michigan without the consent of the court.
I got something to say.
And you have a right to remain silent, and anything you say can be used against you, and you already have an attorney who's talking on your behalf, and I've already granted his motion and changed the bond to personal, so.
Hey, well, I have something to say in response to that.
See everybody at trial.
I have something to say in response.
We'll see everybody at trial.
Mr.
Darren, do you have anything else further?
Your Honor, are we going to set it for a settlement conference, or are we just going to set it straight for a trial?
Sure, I'll set it for a settlement conference, and then a week later it'll be the trial.
All right. Your Honor, I understand the court's position. I mean, if Mr. Martin wishes to make a statement on his behalf, I can only advise him that I wouldn't. But if Mr. Martin wishes to make a statement and the court wishes to hear it, I don't have any. I mean, I'm not going to. I'm advising him not to say anything, but Mr. Martin, if the judge wants to hear it, if he's allowing it, then I'll step aside and let you stay.
Mr. Martin, I've already granted your attorney's motion to set the bond at $2,500 personal. So if you have some other statement you want to make, I'm just going to reassure you again that you have the right to remain silent. Plus, your attorney's already said that, hey, you know what, it's probably a good idea to just do so. But go ahead.
Yes. Like I said, I'm going to exercise my First Amendment right to speak, and I have a lot to say, so I ask that you don't cut me off or I'm done talking. Now, I object to the bond conditions and stuff. I can't be in my house. It violates my due process rights. I have nowhere else to go, and he's not the true victim. He's lying, saying he's a victim, but I told the cops when they arrested me that I was the victim. And so we have an equal protection clause violation.
All of that'll be the subject of the trial itself. So we'll hear everything you have to say about that at trial. Your objections duly noted. But that doesn't change my positions. Mr. Darren, you'll be receiving the date and time for the settlement conference.
Thank you very much, Your Honor. You have a great day.
You too.
Good morning to both of you. This case has been going on since May of last year. In this case, Ms. Simmons has an order for $437 a month as the primary payment for child support, and she has a payment of $87 a month as a repay. For my math, my mind is not that efficient to figure out the amount, so let me just put what he's supposed to be paying. 437 plus 87, I think is what I said. All right, the child support payment is supposed to be $524 a month. Looking at my notes over time, both parties were present in June of last year, and then in August of last year. I've given multiple resets, and then he was here October, and then I dismissed the case because you were consistent in October of 2023. Then in August of 2024, she refiled because you stopped making payments. And then I set a Zoom date. I actually issued a warrant for your arrest. But we reset the case because you came in person and indicated that you did not get the hearing notice. I don't usually give second opportunities when I've worked with you for a whole year to get you back on track, and then you just fall off. Generally, that's a problem because you know you're under an order to pay child support. And I've already given you the opportunity of what I call redeeming yourself. Looking at the order, you have, mom has custody of Abraham, Asher, and Naomi, 3 children. That's not a lot of child support for 3 children anyway, but all right. And so looking at your child support order, it looks like you, mom was receiving unemployment payments for April. And then when we came to court last month, DCSS said that they saw that you may have had a job and they were trying to see if they could get the child support taken directly out of your paycheck. I reset the case to give you a chance that if there's an income deduction order, I would recall the warrant and let the income deduction order continue to proceed, but there's nothing to date. So last payment mom received was April, I believe. And so that's May, June, July, August, September, October, November, 7 months, 3 kids. No support at all, as what I'm showing. Okay, yes, you can raise your hand. Yes, Ms. Simmons.
I submitted evidence as well. It was something that Mr. Simmons had filed with Superior Court, I believe. So I think they may have it. They said they were going to upload it for you to be able to see it.
Okay, give me one moment. Mr. Keys, Joshua, do you see anything from her that you could forward to me?
Yeah, let me give me 1 second. Hold on. I'll look.
Okay, give me one moment, please. And you sent it to the magistrate court clerks, Ms. Simmons? Okay, give me.
Yeah, they made a copy of it. Yeah, I took it into the office.
Okay. All right, well, I'm waiting on the information from Ms. Simmons. Ms. Serena Camarillo, is there any update on the information that was sent in on the ID?
Yeah. I'm not sure when the last meeting with the court was, but I can say that on August 22nd, we received a response from an employer via fax stating that he was no longer employed at the location where we had sent the income withholding order to. They said he was no longer employed there as of August 22nd, 2024.
All right, Mr. Simmons, while I'm waiting for Ms. Simmons' information to be sent, mind you, I've already issued the warrant for your arrest, but you can go ahead and explain to me why you haven't paid any child support in the past 7 months. You have to unmute yourself, sir.
Yes, Your Honor. I'm appearing under special appearance exclusively to address the challenge to jurisdiction. I request that no substantial matters proceed until jurisdiction clarification is fully resolved over my personal property. For the record, I request that all responses to the questions in my demand for clarification on jurisdiction be fully documented in court record. So a clarification of demand that was sent, that should be filed. That's what you're referring to. Demand for clarification of jurisdiction.
Okay. You have a child support order. Ms. Simmons has a child support order in DeKalb County. You are under an order to pay child support. In the state of Georgia, it is a crime to not support your children for 30 days. The law states that the case should be filed where the mother resides with the children. Ms. Simmons, I'm just going to unmute you. Ms. Simmons, where do you reside at this time?
DeKalb County.
DeKalb County, and where do the children reside?
Yeah, also DeKalb County and Stone Mountain.
And where are they attending school? In what jurisdiction?
DeKalb County, Stone Mountain, DeKalb County.
Okay, thank you. For criminal purposes, I do find I have jurisdiction over you, Mr. Simmons. You are the father of these 3 children. There's an existing child support order for you to pay child support. You're failing to pay the child support. You have not paid child support in 7 months. I'm still waiting, so give me one moment before I proceed. You don't want to explain to me why you're not working, what you're doing. You have 3 children with Ms. Simmons, and you're not making any effort to comply with my order. The jurisdiction is determined that I absolutely have jurisdiction over you because your children are not being provided for by you. The last time we received was some unemployment in April and nothing since then. So there's jurisdiction over you. What else do you want to address, Mr. Simmons?
Your Honor, my demand includes several fundamental questions regarding the nature of the court's authority. I respectfully request the court provide clear answers to these questions before asserting jurisdiction over my personal property. Specifically, is the state of Georgia operating as a corporation or as
Sir, I'm not entertaining those questions.
Yes.
Those are sovereign citizens questions, and I'm not answering those questions. So I'm going to mute you for right now. I have jurisdiction over you. I have jurisdiction over your children. This is an appropriate proceeding. This is a government entity, and I have jurisdiction over our court in DeKalb County have jurisdictions over you. So this is the sovereign citizen kind of thing where people act like they're not, or they present that they're not members of the United States. And yeah, no, sorry, sir. You can present whatever you want in writing, but I've already determined I have jurisdiction. You've appeared in court before. You've never made an issue, so I'm not going to let you try to say we don't have jurisdiction over you. You've appeared multiple times before. All right, so give me one moment.
We looked in the inbox as well as look on the file. We do not see anything on file as far as from Ms. Simmons. Not saying she didn't, but we don't see anything in the actual inbox or attached to her file.
Do you have it already scanned, Ms. Simmons?
Myself, no. They did also stamp it to say that it was received by magistrate court as well. So,
okay, well, you can just tell me what it was. What was it?
Yeah, Mr. Simmons, he submitted something apparently to Superior Court. I received a certified copy of a letter in the mail stating basically that he believed that he should not be liable to pay child support because he did not agree to pay child support. Essentially, he said that he was under duress in having to pay child support. Those are cases of his.
All right. So there are a number of entities out that go and challenge jurisdiction and the things that he's trying to do, reading some script of narrative that the judge doesn't have jurisdiction, and sometimes they say they're not a legal person. And yeah, I'm finding that you are a legal person. You've already appeared before the court, so you can't bring any new argument before the court. I do find that you're intentionally abandoning your 3 minor children. So I am issuing the warrant for your arrest, sir. You can turn yourself into DeKalb County Jail. Ms. Simmons, unfortunately, this doesn't expedite. It's just going to go to court. They will arrest him when it's time. They'll take him into custody, and then your case is going to be transferred to state court. So once your case is transferred to state court, Mr. Simmons, if you are recording this proceeding, I am going to hold you in contempt, and I can issue another warrant for your arrest. You are not to record this proceeding.
I'm not actually recording. I'm actually my advice is to make sure that this is being represented accurately.
Are
So-
you recording this proceeding, Mr. Simmons? You're
No,
not.
I'm not recording this proceeding at all.
All right, thank you. Well, I was trying to give you an opportunity to explain why you haven't paid child support. You're determined, you tried to address jurisdiction. I find there's jurisdiction over you, your children. So with that being said, sir, a warrant's been issued for your arrest. You're not providing support since April, and you did good. You got off the case, and then you decided to go this route. That's on you. So $2,000 regular bond. Usually I give unsecured judicial releases, but I'm not because it's your second time before court. You can turn yourself in if you choose. If not, then there'll be a warrant outstanding for your arrest, and when they pick you up,
This
you'll
is okay. I'm making special appearance to actually address the jurisdiction, and so what I'm trying to do is clarify that first. I know you mentioned about jurisdiction, but I'm trying to answer the questions that are in the demand for clarification for jurisdiction. So those questions that was actually submitted, and I'm waiting for you to open.
Oh, that's not me. That's Superior Court. I'm not.
No. I walked it in personally to the magistrate court. I put it in there. The same document she's talking about. I put that.
Okay, sir. You can ask me the questions about jurisdiction. I've already told you I have jurisdiction because your wife and your ex-wife and your 3 children live in DeKalb County under Georgia law. I have jurisdiction over the case. What other question do you have? And because you're the father that birthed those 3 children, you're the one that I find is committing a criminal offense. So a warrant's been issued for your arrest. What question do you have about jurisdiction?
Is this jurisdiction being fully documented in a court of record?
Yes, it is.
Okay. And apart from that, when I mentioned about the request for the court to provide clear answers to the questions before a certain jurisdiction of my personal property, they're written in the clarification for demand that was filed.
I'm not taking any jurisdiction over your personal property, sir. I'm taking jurisdiction over you. And a state court will decide whether or not you're going to go before a judge or jury. So that concludes our hearing, sir. Ms. Simmons, you'll just go to the DeKalb County court, and they will DeKalb County State Court, your case has been transferred. Mr. Simmons has not paid support. Seems like he's not going to pay support. So I would also recommend through child support that you file a motion for contempt, because I'm sure he has the ability to take care of himself. And he sounds to me like he's challenging whether or not these children should be supported by him. So, sir, you could take that up in Superior Court, but for criminal purposes, I've already determined that we have jurisdiction. Okay, that concludes our hearing. Ms. Simmons, if you go to Odyssey,
you do not.
DeKalb County Odyssey, do not unmute yourself without my permission, sir. In Odyssey, you have to track your case. Okay, give it about probably beginning of the year. Go into DeKalb County Odyssey, keep putting his name in until you finally see something come up. And once it comes up, try to go to court if you can to advocate for the child support, because sometimes if mom isn't there, it just makes a difference when moms are active with the court in making sure that the support is provided. And I thought, I don't know, did you have a special needs child? One?
Yes, that's right. Naomi has special needs. Yeah.
Okay.
Yeah.
Okay. I'm so sorry you're going through this, but hopefully you will be able to continue to do the best that you can do with it. All right. That concludes our hearing. All right, Mr. Simmons, you could turn yourself into DeKalb County Jail. If not, there's a warrant outstanding. And when they do a sweep through any different counties, then you'll be arrested and taken into custody. You have a bond of $2,000. And that concludes our hearing. I'll give you one final word if you have a question, Mr. Simmons, but I'm not dealing with jurisdiction questions because I've already determined I have jurisdiction over you. Do you have anything else that you need to say before I conclude the hearing? You can unmute.
I'm here on special appearance.
Okay, thank you. Well, we appreciate your special appearance. You're excused from court. We can go ahead and excuse Mr. Simmons and Ms. Simmons from court, and that concludes our hearing on that case.
This person on the device just labeled Mac. Would you be Stephen Smith?
My Christian appellate name is capital S, lowercase TEPEHEN, capital S, lowercase MITH.
Okay, so that would be a yes. Thank you. Deputy Sims. Now calling 24W003208A, the Township of Ypsilanti versus Stephen Cameron Nigel Smith. Deputy Sims, state your name for the record.
Deputy Sims.
Thank you. Okay, and Mr. Smith, you've already stated and spelled your name out. Thank you. Today is the date and time set for an informal hearing in this matter. What I have is a citation issued November 17th, 2024, that charges that on or about that date you did operate a motor vehicle on Holmes Road at or near Ford Boulevard. And when you were pulled over, you failed to disclose to the officer that you had a concealed pistol and a CPL. So it looks like you were also cited for having a window tint. I don't have that citation, which presumably means that it was paid. So again, this is a civil infraction. There is no criminal penalty associated with this, no jail time, no probation. There is, however, a fine. Before we get started, Deputy Sims, was there anything that you wanted to say?
No, ma'am, I'm ready to proceed.
Okay, thank you. Just a moment. Okay. So, Mr. Smith, as you have likely heard already, you have three basic options when it comes to this citation, and these are your three options. You can accept responsibility, that is basically admit that you did not disclose per MCL 28.425F that you had a license to carry a concealed pistol and that you did not present that immediately to the peace officer when you were pulled over. You can accept responsibility with an explanation, so the court can take into consideration any mitigating factors and potentially lessen or eliminate the fine. Finally, you can deny responsibility, that is, deny that you failed to disclose your CPL immediately, at which point we will proceed to the informal hearing. I will swear in both sides, take testimony, and make a decision based on preponderance of the evidence. Which of those three options are you going with?
I want to, may I grant my name to the court and make the court trustee?
Okay.
But the option three, as your question, I deny responsibility and I have an explanation.
Okay, so if you are denying responsibility, then I'm going to swear you in and swear in the deputy, and I will take testimony from both sides. So let me explain how this is going to work. After I have sworn you both in, I am going to take testimony from Deputy Sims first, because Deputy Sims is the officer in charge of issuing the citation. That means he's basically the plaintiff in this matter, okay? Once he has finished his testimony, which you are not to interrupt, it will be your turn to testify. He is not to interrupt you either. After I've heard the testimony from both sides, I will make a decision based on preponderance of the evidence. As I stated before, that is a 49% to 51% standard. So basically, whoever's testimony is slightly more persuasive. This is not a criminal case. It is not beyond a reasonable doubt in this situation. So, do you comprehend everything that I just said?
I do comprehend.
Thank you. Okay, raise your right hand, Deputy Sims, and Mr. Smith, you will have to tell me when it's raised if you're not turning your camera on.
It's raised.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth to the best of your information, knowledge, and belief, Deputy Sims?
I do.
Mr. Smith?
Yes.
Thank you. Okay. Deputy Sims, you may proceed with your testimony.
On 11/17/2024, about 3 a.m., my partner and I observed a black Ford Fusion. It was on Ford Boulevard. I believe it had just turned onto Ford Boulevard with tinted windows. Proceeded after the car. It turned into the gas station there on the corner, and we followed it into the gas station and proceeded towards one of the exits. Before it returned to the road, the driver, Mr. Smith, exited and began yelling at us. At that point in time, we activated our emergency lights and conducted the traffic stop there. We made contact with him, explained the reason that we had followed behind him. And when I approached the vehicle, I looked in the vehicle and I observed a firearm on the passenger seat. At no point in time during that did I hear I have a CPL until after the firearm was located. He was detained, his CPL was verified, he was issued the citations and released.
And did you have any evidence or witnesses or any other testimony that you wish to present?
Not at this time.
Okay. Thank you. Then, Mr. Smith, it is your turn.
I want to mention there's no damaged property or victim under sworn oath. Also, I believe I was being racially profiled. I had been pulled over, which I did stop, and I was let go because I wasn't suspected of any crimes, just as I wasn't suspected of any crimes by him as well, as he mentioned. We had sat in the intersection, which I was in the middle of a DoorDash, and I wanted to get on my phone to see where I was at. When I looked away from my phone, I seen him, the officer, and another deputy, or whoever it may have been, an officer, also sitting in the middle intersection for about 30 seconds, maybe to even 60 seconds. So he could see me through my windshield. While I believe it was racial profiling, considering the area we were in, it wasn't the best area. So when I pulled, which I did use my turn signal, and it was a stop sign, or it was a light, a signal light. So when the light turned green, I turned right with my turn signal. I also turn signaled into the gas station, which I was going to stop to check my phone, because like I told the officer that had pulled me over 10 minutes before, which I'm sure he heard on the radio call, I was door dashing, which I had admitted to both of the officers. He called another officer in response to what he calls me pulling myself over. He never admitted to pulling me over. He said I pulled myself over. I got out the car to explain myself that I was door dashing and that I felt like I was being harassed because I was just previously pulled over. I did not have a firearm on person, and he didn't have a reason to suspect me of any crimes or try to search my vehicle. I was illegally searched on person without my disclosure. I told them I don't consent to any searches, and they were digging in my pockets. I have a legal license, and I'm not suspected of any crimes. So after he said I pulled myself over, he flashed his lights, and they kind of like grabbed me up, and I feel like they assaulted me in a way. And after he figured out that I did have a CPL disclosure, which he never gave me time to disclose because it was not on my person, so I didn't feel the need to because I was not present in my motor carrier for him to be in any type of danger. After he sat me in the car, which I feel like I should not have been detained that way, for about 15 minutes, they let me be on my way with a citation, and I don't believe I deserve the citation. And he doesn't have any evidence of the situation. It's just a presumption with no material.
Does that conclude your testimony?
Yes.
And did you have any evidence or witnesses that you wanted to present?
I have evidence on my phone of me asking him, what their badge numbers was, which they didn't really want to disclose. So I had to look it up on the internet. I have a dash cam, but it was not running at the time.
So before we continue, I do want to apologize because I did actually have the equipment violation citation as well, but it's for the window tint. So did you wish to address the window tint specifically?
That's just how the car came. I bought it that way, straight from Ford. So it's free.
In Michigan?
Yes.
Deputy Sims, since I don't think I specifically asked you about the tint either because I had misplaced this on my desk, do you wish to address the window tint?
Yes, ma'am. I'm sure you're aware that no vehicle that comes from the factory has front window tint on it. During his first testimony, he admitted to having window tint and said that we saw him through the windshield, which is not possible at night, but he admitted that there was tint.
May I add something?
You may.
There's they didn't test any window tint for any type of darkness issues or anything like that. It was just kind of an excuse, because that wasn't the first reason that he told me that he pulled me over. It wasn't for window tint, and you can disclose that through the video of his own body cam. They said that they pulled me over because he presumed that I was trying to turn around in the parking lot or evade him, but I was door dashing, like I told the officer that pulled me over before.
So, Deputy Sims, I believe when you testified a moment ago, you said you had noticed the window tint. Did you want to respond to that to me, please?
I guess, what are you asking?
You had stated that you initiated the stop, or at least you started to initiate the stop based on observing window tint. Is that correct?
So yeah, I mean, I was with my partner. So there's also the part of he came off of Holmes Road, if I remember correctly, turned right into the parking lot, and then cut through the parking lot to go back onto Holmes Road. It didn't seem like there was any intention of him trying to stop at the store or anything like that. So he's also cutting through the parking lot.
May I add?
You may.
I did not try to cut through the parking lot, as I mentioned before, and prove to the officer before I was door dashing. And if I would have been on my phone, then he would have tried to get me for that as well. So I safely pulled over to where I could view where I was. And it was his presumption that I was trying to turn around in the parking lot, but my car wasn't parked.
Okay, thank you. Give me just a moment. So the court is ready to make a decision in this matter. So in regards to the B ticket, that is the equipment violation, basically having obstructed vision with window tint. At this point, the court is finding you not responsible for the window tint, Mr. Smith, because based on just the testimony today, I don't think there's enough established to confirm whether or not the window tint would have been in violation. Now, regarding the A citation, that being the failure to disclose the CPL, the court is finding you responsible in that matter. And that is, again, based on MCL 28.425F. Basically, an individual licensed under this act to carry a concealed pistol and who is carrying a concealed pistol and who is stopped by a peace officer shall immediately disclose to the peace officer that he or she is carrying a pistol concealed upon your person or in your vehicle.
May I add, please?
Well, no, because at this point I'm making my ruling, and the pistol was in the vehicle. I understand it doesn't sound like you were in the vehicle at this point, but you were engaged with the officer, and it was your responsibility as the person with the CPL to immediately disclose that you had a CPL and that there was a weapon in the vehicle. So you are being found responsible. Again, this is a civil infraction for a first offense. There's a fine here of $500, and your license to carry concealed is being suspended for 6 months. Now, what I am going to say is that you do have the right to appeal my decision as the magistrate. If you do so within the next 7 days, the case will be reheard by the judge. So,
How do I appeal?
You would have to either consult with an attorney or you can talk to the clerks about getting the paperwork. I cannot give you legal advice. So,
Yeah, because I wasn't, as he stated before, sorry, I wasn't actually engaged in a traffic stop. That was the problem.
At this point, the court has made its ruling. This hearing is concluded. I believe that concludes the docket.
Someone named Steph that was just let into the courtroom. Can you please tell us your first and last name? Please unmute your device.
My name is spelled capital S, lowercase t, lowercase e, lowercase p.
Sir, please tell us your name, and I didn't ask you to spell it.
My name is Stephen Smith.
Thank you. We'll call the matter of Ypsilanti Township versus Stephen Smith, case number 24W003208A.
Paul Barnett on behalf of the township.
All right, we're hearing an appeal today. Mr. Smith filed a claim for appeal in this particular matter.
That's correct, Your Honor. I did reach out to Deputy Sims, who is the officer needed to hold this hearing, and he replied to me that he was not available. He's on vacation and out of the state. So I'm asking for an adjournment of the hearing.
Thank you. Mr. Smith, what is your response, sir?
He failed to appear, so I'd like the case to be dismissed.
All right, so this is a carrying a concealed weapon, and he has a concealed weapons license, but he failed to disclose it to the officer. That's what the ticket is.
I believe that's correct, Your Honor.
And Mr. Smith, you understand, sir, that if it is dismissed, they could reauthorize these charges?
No, I don't understand.
All right, well, now I've told you. Now do you understand that, sir?
I don't exactly. I can't say I understand, but I get what you said, but I don't understand the means behind it. So,
Well, that's what the law allows for, any dismissal without it being on the merits of the case. It's without prejudice. Without prejudice means that the prosecution has the ability to reauthorize it.
okay.
Okay. And so is that what you're requesting right now?
Yes, a dismissal.
Mr. Barnett, I think what's going to have to happen in these cases is if you're not going to be able to proceed, you may need to send in a formal request ahead of time so that the court is aware of that.
Understood, yeah.
I'm going to allow them to have it dismissed. All right. Sir, this case will be dismissed. It's probably going to be reauthorized. But at this time, your bond will be returned, okay?
Thank you.
You're welcome.
These 3 hearings all revolve around the same strategic mistake, confusing legal theories with legal obligations. In the eviction case, the dispute stopped being about unpaid rent once the defendant refused to identify himself in the way the court required. That decision prevented the court from reaching any meaningful discussion about the claimed payment dispute. Procedure became more important than the argument. The child support hearing shows a different consequence. Jurisdiction challenges are common in sovereign citizen arguments, but they do not erase an existing court order. When someone ignores the underlying obligation and instead argues that the court lacks authority, the legal exposure continues to grow while the original issue remains unresolved. The final hearing demonstrates the opposite lesson. The defendant successfully used a lawful process by filing an appeal, and the case was dismissed because the required witness was unavailable. That result came from procedural rules recognized by the court, not from sovereign citizen theories. Even then, the judge made it clear the dismissal was without prejudice, meaning the case could return. Across all 3 hearings, the courts consistently focused on one question: whether legal requirements had been met. Personal interpretations, alternate definitions of identity, or jurisdiction scripts could not replace documented obligations, statutory procedures, or established courtroom rules. Courtrooms rarely reward the person with the most unusual legal theory. They reward the person who understands which arguments the law actually recognizes and when to make them. Sometimes the biggest outcome isn't decided by one dramatic moment. It's decided by the strategy chosen long before the hearing begins.